good afternoon, good evening. First, on behalf of the Center for International Law and Policy in Africa, or CILPA for short, I would like to begin by warmly thanking panelists who come to us today from 3 different continents for making time to share their expertise with us for this really exciting 4th and final virtual roundtable in the 2021 International Criminal Court Colloquium Series, co-convened by CILPA, the Nuremberg Academy, and the American Society of International Law. We are particularly delighted to convene this discussion on the challenges and opportunities for African state and civil society engagement in the ICC review process. Over the last little while, there has been a lot of discussion of the ICC review process, but I think this will probably count among the first events, at least that I'm aware of, that's focusing specifically on the concerns of African states and African civil society. Secondly, I also, of course, want to thank each of you in the audience. I know that folks are coming back from the holidays, Christmas and New Year's, so it is a sign of your great interest in issues relating to the ICC and international criminal law more generally, that you've made time to be here for this important conversation. Thirdly, let me also warmly thank and welcome our partner organizations, the American Society of International Law and the Nuremberg Academy. We at CILPA have very much appreciated the close collaboration we've enjoyed with ISIL and the Nuremberg Academy over the past year. The idea behind the series really has been to provide a meaningful platform for African and other experts to engage in debates and discussions of some of the most pressing issues relating to the International Criminal Court today. My name is Charles Jallo. I'm a professor of international and criminal law here at Florida International University in Miami, and I have the privilege of being the founder of CILPA. Before I go to introducing our speakers, let me just invite our partners from ISIL and the Nuremberg Academy, and I will be in a moment introducing our partners. Maybe I should just take a moment and highlight a couple of housekeeping rules, some suggestions for you. I'm sure you're all very familiar with this, having probably participated in many Zoom meetings over the course of the past year or so. So essentially, first is the suggestion to have your microphones on mute when you are not speaking. And secondly, during the Q&A part of the conversation, which will follow the substantive presentations, I will be inviting you to take the floor if you wish to make an intervention. And of course, you're also free, if you like, to use the chat function at the bottom of your screen to put your questions there. And of course, I should note that, like the prior events, this event is going to be recorded. We hope to have a broader engagement by making the discussions available to YouTube and other platforms. Of course, as already mentioned, this is really a function, this meeting today, this event today, of a trilateral partnership, actually, that spans 3 continents. So we have Africa, where CILPA is based. We have the American Society here in North America, and of course, the Nuremberg Academy in Europe. I'm going to start with the American Society, since I actually am physically in Miami and closer to Washington, D.C. And I'm going to invite Mark Agrast, who is the Executive Director and Executive Vice President of the American Society. He has had a very distinguished career as a lawyer, previously served as a Deputy Assistant Attorney General in the U.S. Department of Justice's Office of Legislative Affairs from 2009 to 2014. Mark was a Senior Vice President and Senior Fellow at the Center for American Progress for 6 years, and has held senior staff positions with the U.S. House of Representatives. He actually started in private practice before joining the federal government, having served in Jones Day, Washington office of Jones Day in DC, working on issues of international law. He is a member of the American Law Institute and a life fellow of the American Bar Foundation. I know I've given probably a lengthier introduction than Mark would have liked. So Mark, I'm going to invite you now to give your welcome statement. Thank you very much.
Thank you very much, Charles, and hello, everyone. The American Society is honored to partner with the Center for International Law and Policy in Africa and the International Nuremberg Principles Academy in presenting this final installment of the International Criminal Court Colloquium series. This has been a wonderful and productive collaboration, and I'd like to express my appreciation to SILPA, and particularly to its founder, Professor Charles Jallow, for convening these dialogues. It's also a great pleasure to join in welcoming our distinguished panelists, including Professor Akande, who is a longtime leader of the American Society, in addition to his many other distinctions. Institutions that seek to advance the principles of international law are under considerable pressure today. They need friends who will support and defend the good work they do and who will offer constructive criticism when they fall short. It was in that spirit that the Assembly of State Parties commissioned an independent expert review in 2019 to develop actionable recommendations to strengthen the International Criminal Court and improve its effectiveness. The IER's comprehensive recommendations formed the basis for the work of the review mechanism, which was established a year ago and submitted its final report just last month. In response to the report, the Assembly adopted a resolution, which, among other things, extended the mandate of the review mechanism. The resolution emphasized the importance of continued engagement with civil society and other stakeholders. That's where we come in. Today's colloquium and the three that preceded it are part of that engagement. The three sponsors, based in West Africa, Western Europe, and the United States, have been engaged with the ICC process for many years, and we have a mutual commitment to strengthening the international criminal justice system. What we bring to the table is a readiness to roll up our sleeves and to devote our intellectual capital to that effort. Professor Jallow and his colleagues have once again assembled a distinguished panel of experts from around the world to provide their perspectives on the review process. I look forward to hearing their views and to continuing our partnership in the months and years to come.
Thank you so much, Mark, for those wise words and warm welcome to our speakers from the American Society. I cannot agree more with you, the importance of framing this as, I think, a constructive conversation surrounding one of the most important developments, recent developments concerning the ICC. So thank you very much. And of course, it's a delight to collaborate with you personally, but also with the American Society of International Law. Let me now invite Klaus Rackwitz, who will be speaking on behalf of the Nuremberg Academy. Klaus is the director of the Nuremberg International Principles Academy, and he also has had a very long and distinguished career in actually both domestic and international criminal law, having first served as a judge in Germany, working on, among other things, criminal matters, before he moved to the Ministry of Justice of North Rhine-Westphalia, where he served between 1996 and 2002. He then switched to, I guess he caught the bug, switched to international criminal practice, and just earlier was saying he actually was part of the advanced team, the first German at the ICC in The Hague in 2002. He subsequently, of course, held leadership positions as senior administrative manager in the office of the prosecutor, and of course, later on moved to Eurojust for a few years before he went to the Nuremberg Academy. Klaus, I hope you will forgive me for stopping here. I could go on and on about your background, but let me invite you at this stage to give your welcome remarks. Thank you very much.
Thank you. Thank you very much, Charles. And good morning, good afternoon, good evening to all of you. We are a few days within, but it's never too late. Happy New Year to all of you and my best wishes for 2022. Charles, we are proud and honored as an academy to co-sponsor this important event together with SILPA and the American Society of International Law. It is, I can only applaud to what Mark just said, commemorable that you, Charles, and SILPA organized this round of colloquia on the International Criminal Court. And many thanks, Charles, for bringing us together again today. I personally think that the topic of this discussion today is as timely as it is important. The African group among the states parties of the ICC is still the largest. It's 33 states parties. It's the largest group, and it was not least the African ratification rally, if one may call it like that, in late 2001 and early 2002 that made it possible that the ICC came to life in July 2002. And yes, I had the pleasure of being and the honor of being a member of the advanced teams in these very early days. Charles, actually it was supposed to last 3 weeks, but I missed the bus home and stayed for almost 15 years in The Hague. And yeah, that was a fantastic time. And now, 20 years later, we actually can celebrate 20 years of accord in practice. And that is, again, a result of this early engagement after Rome for bringing the ICC into practice. Of course, a significant number of the court's current cases stem from a situation in African countries. But if we look at the reality, the ICC was and still is the only viable beacon of hope for the victims of crimes allegedly committed on African soil. Alternatives are very rare. The special court for a special criminal court in the Central African Republic is just starting its operation, and it's only limited to the territory of République Centrafricaine. And then we have the Malibu Protocol. It was adopted in 2014. Today, only signed by 15 African states. That's less than half of the number of ICC states parties coming from Africa. And to date, not a single ratification we see of the Malibu Protocol. So that means that victims of alleged crimes on African soil must, and they will, put their hopes in the ICC. And only a functioning and effective ICC may ensure the accountability of perpetrators and give victims a forum to report their sufferings and what has been done to them. And that leads me to the independent expert report, which I think offers a great starting point for the discussion. It will be, from my point of view, important that the African states participate actively in the now starting and ongoing discussion in a meaningful and very visible way. Working groups like the Study Group on Governance should not be dominated by only one or two geographical regions, traditionally dominated by those who have a larger contribution to the ICC's budget than others. The meaningful participation and also the influencing requires time and resources on the African side, but I think it is an investment that may and will pay off. Standing aside and in the worst case blaming the court of being a neo-colonization organization, I think does not help anyone. Certainly does not help the victims of the crime. Yes, colonial wrongs have occurred en masse in the history, not only of Africa, and it's proven that those colonial wrongs have contributed to crimes committed decades after the end of that period. And the more important, based on this experience, is the active engagement of states parties that have such colonial wrongs in their history, that know how victims can suffer if they find no forum and no court to address. Hence, in my view, the reform review mechanism is an opportunity for repositioning of the African group of states parties to the Rome Statute and for increased visibility and participation of African states. I'm very much looking forward to your discussion that we will have in a few moments to tackle these important issues. And thanks again very much to Charles and to Silpa for organizing this fourth round table on the ICC colloquium series. And many thanks indeed to all the panelists who take the time and the effort to be with us today. Back to you, Charles. Thank you.
Thank you so much, Klaus, for those welcoming remarks and substantive remarks as well concerning the wider topic and context for this discussion today. I could not agree more on the need for African state engagement, and it will be very interesting when we get to the substantive panel and the discussions in a moment to see what's really going on, because as like you, I personally see the review process as an opportunity for African states. So before I turn to the substantive part of the program in a few moments, let me just say a couple of things, joining, of course, Mark and Klaus to welcome everyone on behalf of SILPA. SILPA you may not have heard of, actually, because it's a new entity based out of Freetown, Sierra Leone. You can read a little bit more about us on our website, SILPA, CILPA.org. But basically, our principal goal is to contribute to advancing the discourse and building bridges between research, policy, and practice on issues of international law in Africa. We're also very keen on issues of regional law, so in particular, what I call African Union law and its connection to international law, both as vehicles for advancing peace, stability, and security in the African continent. Of course, it would not surprise, I think, anyone in the audience that international criminal law, if we're interested in international law in Africa, would be one of our core priorities. And in fact, we have a big focus in this area. And the reason for that should be quite obvious. International criminal law has been particularly relevant for a variety of complex reasons for African states. And in that scheme, obviously, as Klaus just highlighted, the ICC is very important and quite significant. There are not many centers that focus on both regional and international law. And we're hoping to be able to marry the two and have spaces for conversations on issues like the one we are discussing as part of this series today, but also to back up our own efforts with research that is policy oriented in nature. I might just mention, because we happen to have a representative of the Africa Regional Office of the Open Society in the audience, that I'm grateful to Open Society for the support of SILPA. In a way, without their support, there will be no SILPA and there will be no series. So let me now say a couple of things about the colloquium. Already, as our colleagues have highlighted, we had a number of really interesting discussions. And essentially, the goal is to have a space to have these debates and discussions on issues of international criminal law. And obviously, for me personally, but also for many in Africa and academic, civil society, and states, the ICC is a very important institution, arguably the most important institutional development, in my estimation, since the establishment of the UN in 1945. I mean, we haven't had an organization that shattered, if you will, the frame of reference and the way we think about international law like the ICC has. Yet, when you think about the story around the ICC, there have also been some challenges. So in the series we've had a number of conversations around different topics. So in March of last year, we talked about the ICC prosecutor selection process, where I had the privilege of being a participant, but also we had the chair of that committee and civil society, we had a discussion around those issues. The second roundtable really looked at the role of the prosecutor, the achievements of Fatou Bensouda and her legacy, and of course, the challenges for the incoming prosecutor, Mr. Khan. And then the third event really tried to discuss a little bit of what Klaus was referring to, which is this question of whether there should be a reset of the Africa-ICC relationship. Yet there was still unfinished business because we hadn't addressed more centrally this issue of ICC reform. So the webinar today is really focused on this. And like I said earlier, the prior panels are all available on YouTube, as will be the panel for today. I'm now going to get into a substantive introduction. There could be a lot more to be said about how we got to the review process, but we have experts who've been in the room who've taken time to accept to be part of this discussion. So let me just say a couple of key things before I introduce them and we get to the conversation. The first point, of course, is to note that the idea of having a review of an international criminal tribunal is not exactly a new thing. It's happened before in respect of the Yugoslav Tribunal, Rwanda Tribunal, and of course, the Special Court for Sierra Leone. And what is really particularly interesting to stress about the review process is that it was actually moved by court officials. There's a letter that was sent by the president of the ICC at the time, George Chile Oboy Osuji of Nigeria, who wrote on behalf of himself and the heads of the other ICC organs, essentially to the presidency of the Assembly of States Parties, calling for the establishment of an independent, comprehensive expert review of the ICC's performance. It was based on that invitation by the court itself, which recognized that all is not well, that the ASP decided in December of 2019 to establish the IER process that was tasked principally with looking at issues around governance, the judiciary, investigations, and prosecutions. There is a secondary aspect to the process that really was supposed to be led by the states parties, dealing with issues of cooperation, addressing non-cooperation, complementarity, relationship between the court and national criminal jurisdictions, and ultimately as well issues of equitable geographic and gender balance. The focus of the experts was really meant to be on concrete, achievable, and actionable recommendations. And after a long study, the experts presented in September of 2020 a massive report with 384 recommendations. Now, what was really interesting, and this will be my second point, is despite the various criticisms of the ICC over the years, especially from some states parties, including those in the African region, the report does not, in my estimation, substantively go directly to some of the concerns and recommendations and proposals for improvements of the ICC system that have been made by, for example, the group of states parties, as Klaus said, that constitute the largest regional bloc, that are also particularly important because this is really where the ICC's focus is today. So out of the 384 recommendations, I can't pinpoint a particular one that addressed some of those specific issues that African states have been raising for many years. And interestingly, I only found in paragraph 379 of the report a reference to the African Union. And that is particularly curious because the African Union has been, in a way, both the pro and the con of the ICC for many years. Yet the experts recognized in recommendation 156 that the ICC should engage regional organizations and take opportunities that are available to it to expand its engagement, particularly with entities like the AU. Yet the outcome in the report itself, in my view, does not really go centrally to those issues. So it is on that basis, on that premise, that we need to have a conversation about the participation of states that we convene this panel. So I'm going to basically skip a lot more of what I was going to say so I can go directly to the panel. And we're very delighted to have really distinguished panelists who happen to come from all the different angles in terms of academia, civil society, and of course, very importantly, governments. And we have a terrific lineup of experts who've worked on issues from the perspective of the ICC reform, but also more broadly, international criminal justice. And in many ways, they hardly need any introduction, but let me just try very briefly to introduce them in an abbreviated format. And I'll do it alphabetically by last name as it was on the program, although that does not represent the way I'll be inviting them in terms of what we've agreed for the conversation. So I'll start off with Professor Dapo Akande. Dapo is a professor of international law at the Blavatnik School of Government at the University of Oxford. He is also a fellow of Exeter College, Oxford, and co-director of the Oxford Institute for Ethics, Law, and Armed Conflict. He has served on the board of many distinguished journals and organizations in international law, and in fact was part of the advisory panel for the American Law Institute's project on the fourth restatement of foreign relations law of the United States. Dapo has published extensively, given legal advice to, among others, the African Union Commission on issues relating to the ICC and, of course, the law relating to terrorism. I'm particularly delighted to have Dapo here. As he said, he was part of the third panel, but this is the first opportunity that I can actually say Dapo is also a member-elect of the United Nations International Law Commission. And I have had the immense privilege of serving in that body. And so I very much look forward to having Dapo as a colleague in the commission as of 2023. So Dapo, welcome, and thank you for making time to be here. To the next distinguished speaker, Dr. Yasin Brunga, who is a lecturer in human rights law and co-director of the Gender Justice and Society Research Network at Queen's University, Belfast. She is also a fellow of the Senator George J. Mitchell Institute for Global Peace, Security, and Justice. Her research interests cover a broad spectrum of issues relating to transitional justice, international criminal law, and feminist perspectives on international law. She is currently working on a book project that examines the logics, ontologies, and architecture of transitional justice that will be published by Cambridge University Press. She also has an ongoing project on the transitional process in the Gambia, the recent Truth, Reconciliation, and Reparations Commission. So I'm very delighted to have her. She's been a very important voice on marginalized communities and their experiences from the perspective of what one might call colloquially Global South. And I'm putting air quotes on purpose on this, with a particular focus on Africa. And Yasin will be speaking to the issues from the perspective of some of our work, especially relating to the Office of the Prosecutor. So welcome to you as well, Yasin, and thank you for making time to be here. To our third speaker, Michael Cano, who of course is listed third, but actually will be our first speaker for reasons I'll explain momentarily. He is a compatriot of mine, currently ambassador and deputy permanent representative of Sierra Leone to the United Nations, responsible for legal affairs. Ambassador Cano began his career as a national legal associate at the Special Court for Sierra Leone and has since then developed keen interest on issues of international criminal justice. In a way, I see him and myself as legacies of the Special Court for Sierra Leone. In that capacity, as an ambassador and deputy permanent representative, he's actually taking an important leadership role in the African group in New York. And as part of this, has been involved as a representative or co-chair of the ICC review mechanism. That's particularly relevant for the discussion we're having here today. I should probably also note that before he joined the ICC process as a co-chair of the review mechanism, he was in fact the coordinator of the African group of experts on the ICC review process itself. So he really brings to bear the perspective of an individual state, but also the group as a whole, but also the perspective of the ICC as someone who is deeply involved, along with Ambassador Van den Ijzel from the Netherlands as co-facilitators of the review process. So I'm delighted that Michael could be here. Michael actually had, for the first time, tried to take a vacation. I know this because I've been dealing with Michael a lot, and of course, I still dragged him out of his vacation to be here. So Michael, thank you for making time to be here and for sharing your expertise with us. The final speaker, this is last but not least, certainly not least, is Sharon Nakanda, who is a Ugandan trained lawyer with an LLM in public international law from the University of Leiden. Sharon, as I mentioned earlier, comes from she's a program officer, but comes from the Open Society Foundation's Africa Regional Office that's based in Dakar. And she works basically on the international justice portfolio. She was a member of the external team of lawyers that represented victims in the ongoing trial before the ICC, and also has served as a director of the Victims Support Initiative, which is a national victims advocacy group in Uganda. Sharon, I should add, has been a close watcher of the ICC Africa Relationship, and she's been particularly engaged on the issues relating to the role of African civil society in the work of the IAR. So we're really delighted to have Sharon with us, and she would complement, as you see, the wide variety of perspectives that we hope to offer you today from academia, and of course, from a state perspective, but also from civil society. So this is really quite a stellar lineup. At this stage, I should not do anything more than really invite, as you can see with the great expertise we have in the room, our first speaker, who is Ambassador Cano, who's agreed to essentially set the stage. Like, I know that not everybody has had the time to look at that lengthy report from the IAR, and of course, all the subsequent documentation that has been produced. And so what Ambassador Cano was invited to do was to give us a bit of an overview of the review process, stressing in particular his role as a co-facilitator of the review mechanism and that perspective that he brings to the table. So Michael, I'm going to invite you to unmute yourself. Thank you for taking time. You can have up to 15 minutes for your intervention. So feel free to proceed at any time. Thank you very much.
Thank you, Professor Jallo. I'm sure our guests will permit me to also congratulate you on your re-election as a member of the International Law Commission, and use this opportunity to congratulate as well Professor Kennedy. Distinguished co-panelists, member state representatives, members of civil society and academia, distinguished guests. It is indeed a great pleasure to have been invited to speak on this timely and intriguing topic. Let me start by commending the host, Center for International Law and Policy in Africa, co-sponsors the American Society of International Law, and the International Newburgh Principal Academy for bringing us together in the new year. Of course, SILPA for convening us in terms of the dialogue. Our topic for consideration calls for an examination of the relationship between Africa and the ICC, in particular the review process. If I could paraphrase the title. And as one of the two state party representatives and co-chair in the review mechanism, I will take some time to really preface my talk with a quick look at the review process and the work that has been done by the review mechanism. And because of the limitation of time, I will only benchmark the most significant steps. As a preface, and indeed, I think you've touched on this, Professor Jallo, the ICC had remarkable success in almost 20 years of operation. But also, as could be gleaned from the concept note, the court has faced criticism over time. There was a brief allusion to the African bias criticism, but on more substantive matters, there are questions on the quality of the investigations and prosecutions, controversial judicial decisions, institutional work culture that was called into question, and overall operational inefficiencies. The state parties related criticism would include question on adequate budgetary support, non-cooperation, external threat, and of course, there was an actual attack on the court from a non-state party. As explained already, and as we know, the first significant step in the review aimed at strengthening the court took place in May 2019, when the principals of the court agreed and called for an independent expert review. This actually followed a lot of calls from state parties in both formal and informal engagement. This was followed up in June 2019 with a retreat by the Bureau of the ICC Assembly of State Parties to find a way to address the challenges highlighted and to strengthen the court and the Rome Statute System. So I had prepared to go into the mandate you will find in the ICC ASP Resolution 18-7, but I think Professor Jallo, you've highlighted a bit of that, so I'll just skip because of time. Happy to talk about the mandate of the review, including the issue of the three thematic clusters of governance, judiciary, investigation, and prosecution. And I will say that an important issue to note was that the state parties agreed that to be successful, the review process must involve all state parties, the court, and other relevant stakeholders. And further, the process must fully respect the statutory independence of the court. These are key principles which really directed the work of the review mechanism. Again, there have been reference to the priority issues that were identified for the state parties to address directly, stemming from the strengthening of cooperation, addressing non-cooperation complementarity, and equitable geographical representation and gender balance. The only thing I will say is that in the resolution ICSP 19-7, this is the 2000 resolution, this was referred to as the remaining issues. So reference to the IER recommendations and the work of the review mechanism would cover those recommendations and the remaining issues which were identified for state parties to really address. In terms of the timeline of the review process, as we already note, the independent experts commenced their work in January 2020. And despite the outbreak of the coronavirus in 2019, the panel presented its report as scheduled in September 2020, containing 384 recommendations. So it wasn't an ideal circumstance, and of course, that had implications in terms of engagement and representation. In December 2020, the ASP adopted resolution ICSP 19-7 on the review process, and in the resolution, the state parties welcomed the report and the recommendations of the independent experts, and took note of the diverse, thorough, and extensive nature of the recommendations and the need for them to be addressed in a structured, holistic, and result-oriented way. This gave the impetus for the establishment of a review mechanism dedicated to planning, coordinating, keeping track, and regulating, and regularly reporting on the assessment of the recommendations, as well as the remaining issues, and any further action on the recommendations as appropriate. In February 2021, the Bureau, as mandated by the Assembly, appointed the members of the review mechanisms with two state party representatives from the Netherlands and Sierra Leone, so that's Western Europe and others group, and the African state parties, as co-chairs, and then we have three ad-country focal points from Bangladesh, Asia Pacific, Chile from GULAC, and Poland from the Eastern European group. Clearly a representative body, and I will shortly discuss the rationale behind the composition of the mechanism. The resolution tasked the mechanism and the court with several outputs for 2021, and for which there was due compliance. This is really an incredible feat given the challenging circumstances and the overall ambitious nature of the project. The court submitted its overall response to the report of the independent expert in May 2021. For people familiar with audit exercises, this could be a sort of a management response to the audit, the court report. Also in April 2021, the review mechanism submitted to the Bureau for consideration a proposal for categorization of the independent expert recommendation and the remaining issues. And the categorization was done according to the entity responsible for addressing the issue concerned. Categorization was adopted by the Bureau on 31st May 2021. And this really has directed the work of the review mechanism as to which entity, which institution, whether it's the assembly, the court, that would address the recommendations. In June 2021, the review mechanism submitted to the Bureau the proposal for a comprehensive action plan for the assessment of the recommendations, including requirements for possible further action. The Bureau also adopted this comprehensive action plan, and this is really the structured approach which the state party had anticipated when they adopted the resolution. Over time, the review mechanism submitted the required report to aid transparency in the process. Given the time consideration, I'll probably just try to go into part of the African relationship. But let me just note that the work of the review mechanism is in a dedicated page on the website of the ICC-ASP. And I encourage you to visit the webpage for any further information on the issues which I've highlighted. I will only conclude this part by referring to the two resolutions that were adopted in the last ASP in December 2021. And that's the 20-3, which really I would call the review omnibus resolution, because this dealt with the general issues, including the extending the mandate of the review mechanism. And we have the ICSP 20-4, which is on the outcome of the work of the study group on governance on the recommendations of the group of independent experts. Reference was made to the SDG earlier on. This is the first set of outcomes on the IAR recommendation itself on the procedure to amend the rules of procedure and evidence. And those are recommendations 381 to 384, and the elections of the registrar, recommendation 76 to 78. These are the first fruits of the review process, a clear demonstration of the commitment of the state parties, the court and stakeholders in implementing the assessed recommendations of the independent expert. Now to the focus on African states and African state context and engagement. Following the overview of the review process, I think it's now good to look at the opportunities and challenges which the review process has offered to the African state parties. Let me start by noting that the focus on Africa is relevant and appropriate, and I agree with Klaus in terms of the issues which you've mentioned. African state parties constitute the largest regional group within the Rome Statute System. The continent has had most of the situations under investigation and prosecution, and the court has enjoyed crucial support from the African state parties over time. Also, the court has faced the African bias criticism, and together with the ASP, it must meaningfully address the issue of equitable geographical representation or the lack thereof in order to reinforce the universal character of the court and the Rome Statute System. Much like the negotiations leading to the conclusion of the Rome Statute, African state parties have been very active in the review process. From the June 2019 Bureau retreat, there is the legitimate expectation that the review process will offer the opportunity to address some of the long-standing Africa-specific concerns. And this is where I will start with a look at the Icc and Africa relationship. We do not have time, and a bit has been said on this. The only thing I will say is that it is well documented that this is a complex relationship. We can draw a distinction between the ICC's relationship with Africa in the normative sense, and also in the context of the courts and state parties, African state parties, the relationship with African non-state parties, including situation countries, and the relationship with the African Union itself as an institution. Significantly, what I can say with all that we know is that there's been ebb and flow. The relationship has been supportive on the one hand, and we saw a decline which started in 2008. However, I think there is a move towards a constructive engagement stemming from the Addis Ababa retreat, but also the submission that was made by the African Union in the Jordan Corporation case. It is from this backdrop that the review process may have been seen as an opportunity. And in the African Union Summit decision on the ICC before the ICC ASP 18, where the first review resolution was adopted, the African Union's highest decision-making body, among other things, urged state parties to the Rome Statute, in particular, and I quote, African states to stand against the increasing politicization of the court. And it requested the African Union Commission, in consultation with the African groups in The Hague and New York, to develop a matrix of issues of concerns to African states, including issues relating to the rights of the accused and immunities of heads of state and government and other senior officials, and to propose the necessary amendments to the Rome Statute within the ambit of ongoing discussions on the reform of the ICC by the Assembly of State Parties, end of quote. In a meeting convened by the African state parties in The Hague, this was led by Zambia, together with the African Union Legal Council during the ICC ASP 18. Sierra Leone was appointed to coordinate the African group on the IER process. At the ASP 18 session, two important issues were critical for the African state parties as a sort of precondition to agree to a consensus resolution. Those were representativeness of the independent expert and unhindered access to confidential information for the experts. The African group was indeed satisfied with the list of experts that was circulated by the presidency of the ASP before the adoption of the resolution. And Sierra Leone delivered an explanation of position on the issue of unhindered access relating to confidential information. I think the next issue that arose in terms of the work of the independent expert was really effective engagement. The experts were based in The Hague and they had planned a visit to New York. However, due to the COVID-19 outbreak, consultation with the New York working group was limited to only an online briefing. With a limited representation in The Hague, it was not a surprise when on the 30th June, the IER panel of experts submitted their interim report with the indication that only one African state party met with the experts or submitted a written observation. Indeed, if African priorities were going to be factored into the work of the experts, then effective engagement was an imperative. Therefore, to ensure inclusivity and adequate representation in the IER process, the African group in New York established an open-ended drafting committee to compile all existing proposals submitted by African state parties in a matrix form, and this formed the basis of the African state parties submission. The submission, in a way, synthesized and prioritized relevant issues to be addressed according to the clusters of the review. And this goes into the point which was earlier made by you, Charles, as to the issues that were covered in the review process. So the submission had to be tailored to the clusters in the terms of reference in the review. The submission highlighted opportunities in which the court's action could be appropriately oriented, knowing the crucial need of the expert review to be effective and be perceived as credible and legitimate by all stakeholders. Although the submission was made in July 2020, the experts through the chair duly acknowledged the submission. Of course, there was an issue as to whether the review should include amendments to the Rome Statute. It was the view of the expert in terms of communication with the African group that that was outside of their mandate, and perhaps that's the reason why some of the other issues were also not addressed by the independent expert in the recommendation. With the submission of the report by the independent expert, which the African state parties duly welcomed, there was a clear call for assessment of the recommendations for possible implementation. In trying to agree to a process or mechanism to do so, the issue of representation to ensure legitimacy became critical for the African group. In the initiation of the resolution, that's ICC ASP 19-7, the African state parties prioritized the issues of inclusivity and transparency, safeguarding the judicial and prosecutorial independence of the court, and representation. Despite the significant debate on the need for efficiency in the mechanism that was going to be established, the African state parties remained resolute on the issue of representation and hence legitimacy of the process. The composition of the review mechanism with 2 state parties representatives and 3 ad-country focal points reflects really the compromise that was reached between these 2 big issue of efficiency versus legitimacy, which indeed, as shown, was not mutually exclusive. Whilst the 2 state party representatives are expected to drive the work of the mechanism, we have 3 ad-country focal points that will ensure legitimacy for all the geographical regional groups because they were represented and there was a requirement for them to be briefed regularly. As to the assessment of the recommendations, and as the recommendations really, the assessment gathered pace, the perennial challenge faced by African states and other small state parties with really small delegations re-emerged. With the allocation of the recommendations to the various ASP mandates in The Hague and in New York, and the volume of work that was required, effective engagement became an issue. Engagement continued in New York with representation by Côte d'Ivoire as the new African state parties coordinator on the Icc issue. However, there was, and it still is, a location limitation and time zone challenge for virtual meetings that were held in The Hague. African state parties admirably kept abreast by the coordinator and briefed during regional consultation, but certainly this was not adequate, particularly in the budget discussion where engagement was really limited. So this is really a significant challenge that remains to be resolved. However, there is a silver lining. African state parties do have significant responsibilities in the assessment of the IAR recommendations, particularly on some of the sensitive issues. As co-chair of the review mechanism, I am from the African group, and I am expected to brief my group, even though the mechanism itself would not take substantive position on issues. But of course, we are aware of the importance of informing and consulting with the regional groups in the work of the review mechanism. Similarly, on the facilitations relating to complementarity and cooperation, we have African state parties representatives as co-chairs leading the work of those facilitations. The 2 distinguished ambassadors from Uganda on complementarity and Senegal on cooperation respectively do take the African context in terms of their work, because of course we get to hear when they take the floor on issues and when they lead their facilitation. Further, on the work done by the study group on governance, and this is significant, the outcome of its work that is reflected in the ICSP 2024 resolution on the election of the registrar. This was led by the African focal point from Kenya in the study group. The core objective of the work that was done is to really strengthen the participation of state parties in the upcoming election of the registrar in 2023. And this is an issue of high interest and importance to the African state parties. So really in terms of just concluding on this point in the African group, African state parties engagement, I wish to reflect on the issue of inclusivity and the challenges that the African civil society has expressed relating to the review and the work of the review mechanism. I know my dear colleague and friend will have to address this. So I would just say, as a mechanism, owing to the COVID-19 pandemic, the meetings on the recommendations were held virtually, and the known challenges of time zone connectivity well documented. Significantly, there was also the critical issue of multilingualism, particularly for situation countries. Malheureusement, je ne parle pas français très bien, so I don't speak French, and so we had to find translators for the review mechanism meetings. So getting a secured platform with translation services was a big issue at the time, and certainly there is the usual rationalization of translation services. So this may be seen as a technical point, which is very important as a bureaucratic point, what is very important to really facilitate transparency, but also the participation of civil society in the very technical discussions that took place in the assessment of the recommendations. And even though there were improvements by the end of 2021, this is one issue which required much work. Let me really end by going back. I know I might not be doing well with time, to what was said by the African group in the ASP 20 plenary on the review process. In the statement delivered by Côte d'Ivoire on behalf of the African state parties, the group took note with satisfaction of the report of the review mechanism and encouraged the review mechanism to continue its ambitious approach and maintain the current pace of the review process. So this gives you an insight as to how the group has viewed the work of the review mechanism and the pace that should continue, even though it's really challenging. The African state parties reaffirm commitment to the review process for the strengthening of the court and its effectiveness to inter alia good governance, the principle of complementarity, cooperation, and the promotion of equitable geographical representation and gender balance. In fully committing to remain engaged in the process, reference was made to the African Union Heads and Government decision on the ICC urging for an engagement in the review process and to address the issue of politicization of the court. The statement concluded with the optimistic view that the African state parties remain convinced, and I quote, in their hope that our collective effort in the review of the ICC and the Rome Statute System, as well as the work of the review mechanism, will contribute to strengthening the court and the Rome Statute System in its effectiveness, legitimacy, and capacity to deliver effective justice and end impunity for atrocity crimes. I can only submit that as the review takes on an ambitious approach, the challenge of ensuring inclusivity and transparency is immense, as I personally feel the weight as a co-chair from a very small delegation. However, there is real optimism, this sense of genuine effort to make the process inclusive and transparent for much needed legitimacy, and for collective delivery on the promise of the review process. I should stop now, and then I'm happy to answer any questions that you may have. And thank you for your kind attention. Thank you, James.
Thank you so much, Ambassador Cano. That was a deep and substantive, quite comprehensive overview of where we are. And I particularly liked your stress in terms of your prior role as coordinator of the African group in New York. Not a lot of people from outside, so I'm glad you could share with us, are aware that there was an African state submission to the process. And it's also very interesting to hear your view concerning why those concerns may not have been addressed, including this idea that the role of the independent expert review process was not to propose statutory amendments to the Rome Statute. I think it's fair to say, and we'll get to these issues momentarily, that they did dock some fairly sensitive issues. And so a lot of proposals were made. For the issue of funding was not addressed. Obviously, the role of the ASP as a support oversight body for the court, dealing with the states parties, issues of non-cooperation is also a sensitive issue. The number of really sensitive points that didn't come up. And then this principle that we're not going to talk about statutory amendments and kind of hide behind the idea of what the process limits, I think was a lost opportunity. But that's my own personal view, and I don't want to presage anything. I'll come to those issues later on. So thank you so much, Michael, for a really very comprehensive overview. You raised a lot of issues. I hope that we'll be able to pick them up right away as we go into the presentations, but also very much in the discussion. So let me, because you talked about the challenges at the end, and I like that. It's a good segue for me to talk to Sharon, right? I'm going to invite Sharon because Sharon sits in Dakar and then she's in Kampala the next week, but also really closely monitoring what's happening with African civil society. And you talked about, Michael, the challenges of connectivity in terms of participation through online meetings, language issues, and I'm sure there's more, right? So one thing that has struck me, Sharon, is that we haven't seen a lot of African civil society in the discussion, given the significance of the continent and the support of African civil society for the ICC. So Sharon, why don't you take 10 minutes, give us your sense of where things are, and then we'll continue the conversation from there.
Yeah, thank you, Charles. First of all, I guess when we first heard about the IER process, we were optimistic, we were excited. We said, finally, we're going to have a better institution. This is a process that African civil society welcomed. But of course, it was quite cautious on our end, because in the past, one of the key questions a colleague asked me is that, will this result in any change at the end of the day? We may waste so much, so many resources, we may waste so much time, and then nothing changes within the institution. So it was cautious optimism. But on our end, for example, at the Open Society Africa Regional Office, one of the first steps, we were equally happy. We said, okay, let's give it a shot, despite some of the disappointments we've seen in the past. And that is how we ended up supporting the Africa Network on International Criminal Justice, which brings together several NGOs, African NGOs across the continent. But lo and behold, the IER process commences, and then we have a pandemic that just throws everything into, for lack of a better word, chaos. So here we were, the groups were going to convene in person to discuss, some of their recommendations. At the end of the day, what they had to resort to was send out a questionnaire, because at that time we now had travel restrictions. So while their recommendation was quoted in the interim report, if you look realistically, not as many NGOs engaged because they likely didn't receive the questionnaire, or if they got it, responding to it. That was the start of what I could say was, it was complicated, and it has, we've seen it happen consistently. But at the same time, I have to say that while we were, one of the opportunities I saw, for example, with this process, is that we could finally have that cross-regional reflection on the ICC as well, across continents. So not only looking at what Africa's issues are not only knowing what Africa's issues are with the ICC, but also knowing what other continents, some of the concerns that they face when it comes to engaging the ICC. Now, looking at, finally, when we have a report, when we have the process continuing, you notice that there has been limited Africa CSO engagement in the process. And in reflections with colleagues, we've come up with some sort of theories on why this may have been the case. So first off, you have general frustration with the ICC and how very little has been done to improve, despite complaints. I've been myself in meetings with ICC officials. You raise issues, they claim they're listening to you. In the end, they don't do anything about what you have raised. So there is that. So that may explain the level of disengagement in this. Then, of course, generally, while Charles, I may share your optimism, the ICC, important institution, the reality is that there is diminished popularity of the institution on the continent for a number of reasons. I've had friends who have told me, oh, you work on, that institution whose cases never end. Can you imagine being told that? So there is just that level of, frustration with the ICC. And of course, the issues that Ambassador Cano touched upon, connectivity challenges. And in this new COVID world, I recall that in Feb 2020, when the experts held an online meeting, I myself from Dakar could hardly hear throughout, I was just trying to listen in, but connectivity was horrible. And if you actually want to hear the views of CSOs that engage directly with communities, they're often not located, say, in the capitals. And you need those kinds of voices, you need those perspectives. So I think while, yes, we may blame COVID, but there was a lost opportunity with the experts actually going to situation countries and engaging with not only CSOs, but also victim communities who have actually worked with the ICC, who know this institution, who will tell you where the improvements should be, and who will tell you what the priorities should be. And of course, language barrier, that is always a concern, like Ambassador Cano said, and you, Charles, too, articulated. But I don't want us to make it as, it shouldn't be that simplistic. So it's one thing, over time, we have translated documents, you now have translated documents, you have some meetings that will have interpretation, but it's not only that at the moment. I have to admit that a 348-page document is not something which I'm guessing even many of us on this call have not had time to comb through that entire bulky document. And then you have, again, the matrix. If somebody receives the matrix without the context or simplified version of, say, the report, they're not going to have the necessary context to actually provide substantive feedback. So I think there is room, and maybe this is where the review mechanism has to engage some of the existing CSO platforms. You have the CICC, you have the African Network on International Criminal Justice. They may have their own internal challenges, including some of those that we are raising, the criticisms we raise about the review mechanism. But I think they provide some sort of platform to engage NGOs on the ground. I have to say too that the IER process was, it was very short in my view. That timeline was unrealistic. If you actually want to get, proper feedback, it needed to be extensive in many ways. And then going back to, colleagues have asked again, why aren't we seeing African CSOs participate in these calls, on these panels? And I have 2 reality checks. COVID is a livelihood concern for many NGOs. It has presented that. COVID has impacted democracy on the continent. So a lot of NGOs have diverted their focus to that. So right now, in the set of priorities, the ICC that does not necessarily impact their livelihood on a daily is quickly forgotten. Then, of course, we know that this is a state-led process. Oh, I see a comment. Can you hear me okay?
Yes, Sharon, I can hear you. There's a comment, I think, from Hans Corell, who is suggesting that there might be a speaker in the room. So if you could mute that, if that doesn't mute what you are, how we can hear you, it will help me hear you better.
Okay, I hope it's okay. There is no speaker, but I hope it's fine.
Okay, good.
Yeah,
it's definitely much better, I think.
Yeah, okay, oh good. Yeah, so the other thing that we expected from the onset was closer collaboration or work with our African state parties. We didn't see much of that. It was also hard to tell whether African state parties even wanted to engage CSOs. I know we've had a very complex relationship over time, but it would have been good to see this happening on a regular, for us to talk and see what the issues are, what should be articulated before the review mechanism. And at the moment, so one of the key priorities of African states, for example, work around the Trust Fund for Victims, victim participation, the field presence of the ICC, engagement with civil society organizations of the different organs within the ICC. Those are critical issues, but we've seen that in the first year, they've not been prioritized. So that may also explain why civil society is not as engaged. And so, we've discussed, you've had discussions around governance, workplace culture, elections. Those are important issues, but we see them we find that states are the ones that are leading the conversation, and CSOs are only involved as an afterthought. So that may explain the level of disengagement that you may see over time. Now, what CSOs want to see is a court that is physically closer to the victim communities it seeks to serve. That is important. They want to see mutually beneficial and strong relationships with various organs of the ICC. That is the vision. And if if the RM is working on something, those should be the priorities. And of course, we want to see the ICC lead the change. While we appreciate the role of states, we want to see the ICC get to the point where it's saying we are going to implement some of these recommendations. And that is something perhaps positive from the ICC response to the report. The fact that you at least have some also acknowledgement that there are gaps with the institution, but also that there is room for improvement and that they may implement some of the recommendations. The other thing that we wanted to see, and which unfortunately was thrown out the window over time, was agency of African CSOs. Up until now, if you look closely, African NGOs have not engaged independently in this process outside the global institutions and platforms they belong to. We haven't seen that. So that for us was really significant. That is what we wanted to see, that finally African NGOs, African CSOs had a voice in the room. But it hasn't happened because of the numerous challenges that I have raised. And of course, we need, one of the key reasons why we need these CSOs, African CSOs involved, is because they are the closest to the communities. They've had a more long-term relationship working with the ICC. They've tabled recommendations informally through discussions with the ICC. And so they would have something critical to contribute to this process. So for the review mechanism, I think key thing is that once we actually touch on the issues that are very relevant to African CSOs, things that they see as priorities, then we are likely to see their participation shoot up. Yeah, so I'll stop there and welcome any questions. Apologies for the sound, but making do. And these are some of the challenges that I have mentioned. Thank you.
Thank you so much, Sharon. I think it's good of Hans to raise this issue, but as you said, we also know that this is something that constitutes a perfect example of the problem. And we actually saw it with the ICC prosecutor process. We had an interview with the prosecutor candidate from Uganda with all the famous internet issues that everybody's aware of. So it really goes to illustrate very well some of the difficulties in terms of engagement from the continent. And I took note of Sharon, of a couple of things that I want to highlight that connect very nicely with what Ambassador Cano was saying concerning, one, the pandemic and the logistical issues, and secondly, the issue of the timeline. I was quite surprised that despite the pandemic, that they proceeded with the calendar, and it's to the credit of the experts and their commitment to the process to actually want to lead it in the way that it was set out. But definitely the pandemic did raise a number of issues for the process, and I think Ambassador Cano highlighted those. A third point, which is really interesting to me, that I hope we'll come back to, relates to the agency of the African civil society organizations. One of the things that I find very interesting is that the civil society on the continent have been quite engaged on the ICC, strong supporters, sometimes pushing back at African governments, the AU and so on. But in some ways, with the pandemic happening and other priorities, oftentimes there's a funding limitation, the attention has gone elsewhere. So it will be interesting to see how we can bring them back into the discussion, given that we're still in the early phases of the process. This has been really fantastic. A lot more other points that connect nicely, but let me at this point move to Dapo so that Dapo can add now to the conversation that takes into account both what you were saying, Sharon, from the civil society perspective, a real on-the-ground perspective, and also what Ambassador Cano from sort of like a more high-level perspective in terms of the state process, and now from academia, right? So Dapo, who's been watching and listening very carefully and also followed very much Africa ICC relationship. So Dapo, why don't you come in, take 10 minutes and kind of connect some dots for us.
Thank you very much, Charles, and thanks to the co-organizers as well, the American Society of International Law, and of course, the International Nuremberg Principles Academy, not only for inviting me, but actually much more importantly, for hosting this important discussion. In the last webinar that Silpa hosted in this series, we talked already about the relationship between Africa and the ICC and whether it was time to reset that relationship. And in the context of that webinar, a number of people, of course, identified some of the key concerns that African states have had with regard to that relationship between the court and the continent. what I would like to do in the time that I have available is, in one sense, maybe to pick up a bit actually from where Ambassador Cano sort of left off, because he was talking about, he gave us an excellent overview of the process, but he also gave us an excellent overview of the role that African states played in the process. What I want to do is to focus on the extent to which the independent expert review took into account the concerns that African states, so the states themselves, had expressed about the work of the ICC over time. And Charles already has referred to some of this. And it's interesting, of course, that the independent expert review was stated to be part of a state-driven review process. So it was, in one sense, initiated by states, and even though it was independent, it was part of this broader process of the assemblies of states parties looking at the work of the ICC. As Klaus already reminded us, African states, of course, still constitute the largest state constituency amongst the states parties to the ICC. And African states have expressed many concerns about the ICC. And the question really is, to what extent has this review process, which is supposed to be part of that state-driven process, to what extent has it responded to the concerns that African states have expressed about the work of the ICC? Now, over time, over the last, I don't know, sort of 14, 15 years or thereabouts, African states have not only expressed some concerns about the work of the ICC, but they've also made some specific proposals with respect to changing aspects of the operation of the court. Now, I would suggest that many of the concerns of African states with respect to the ICC and many of the proposals for reform have centered around the issue of peace and justice and the relationship between peace and justice. So, of course, there are a number of much more specific questions that have arisen. We talked last time about the immunity issue in relation to prosecutions of heads of states, but at least the way in which they have been expressed by African states, and for the moment, by the way, I'm not actually making any comment myself about those proposals, but at least from the perspective of the African states and from the way in which they have addressed these proposals, they have made these proposals as coming from the peace versus justice debate. So many of these proposals have centered around issues of how do we try to ensure that the work of the ICC is respectful of peace negotiations and other peace processes that are going on, and how do we try to ensure that the work of the ICC does not derail the prospects for peace. That's the way in which African states have expressed their concerns. So let's look very briefly at some of the key proposals that African states have made from this perspective. First of all, there's been all of the debate around deferrals of investigations and deferrals of prosecutions. Everyone listening, I'm sure, is familiar with Article 16 of the Rome Statute, which gives the Security Council the power to defer for 12 months, renewable investigations and prosecutions. And African states have said that on occasion, it is appropriate for these investigations to be deferred in order to allow a greater opportunity for these peace negotiations to develop and take effect. In fact, a number of people on this panel have worked on these issues. I know Yasin, of course, has written on this, as has Charles. In fact, Charles and I have written together also on this issue. And African states back in 2008, 2009, made a specific proposal to allow, a specific proposal regarding the amendment of Article 16, which would have expanded the deferral power in the sense that it would have provided not only for the Security Council to be able to defer, but also the UN General Assembly to be able to defer investigations in situations where the Security Council fails to do so. So that's a specific proposal that African states made, as I say, out of this this desire to be able to try to marry considerations relating to peace with considerations relating to justice. Then, of course, there have been all the immunity debates and issues which we are all familiar with. And in that context, sorry, just to go back to the deferral one, that proposal to amend the statute was made specifically by South Africa on behalf of African states as a whole, and in response actually to a decision that was made by the AU. And then the immunity issues that we're all familiar with. Kenya also made a proposal a bit later on to, a couple of proposals actually, to amend the statute of the ICC in relation to prosecutions dealing with heads of states. Of course, born out of the experience that Kenya herself had with the Kenyan head of state being on trial. But specifically, there was a proposal to amend Article 27 of the ICC statute and to provide for immunity of serving heads of states and a limited group of other officials. Now, without commenting on this, the specific merits of this proposal or these proposals, I think the thing that's striking about the independent expert review is that it actually does not discuss at all any of these proposals, nor does it actually take into account the wider concerns behind those proposals, the wider concerns being, how do we deal with the peace and justice debate? None of this, at least as far as I can tell, is to be found in the response of the independent expert review. One possible justification for that approach that was taken by the experts is to say, well, they were, and in fact, they say that they were mainly focused on identifying actionable proposals, and that for the most part, they were looking at proposals with regard to the operation of the court, which would not require amendments to the Rome Statute. And I think that's reasonable. It's reasonable to say, well, if you really want to make change, it's not very likely that you're going to see immediate change by pushing for proposals to amend the statute. And so what they were trying to do was to say, what can be changed immediately? But I think there are two responses that can be made to this, that can be made to this point, that the mandate was in one sense limited. Now, this wasn't actually the mandate from the SP. This was the interpretation of the mandate by the experts themselves. They wanted actionable proposals. So I think there are two, maybe even three responses that can be made. I think the first response that one might make is to say, well, if you have a set of concerns that are really important to a large group of states, then it's important to deal with them. It's important to think about them, even if the path to achieving what those states want to achieve is not necessarily one which would lead to immediate change, right? So this is an important group of states because of the numbers. It's important because of what we have seen in relation to the ICC over the last few years, with dissatisfaction from at least some African states and the threats of withdrawals that we saw, and that at least there should have been some attempt to respond to some of those concerns. And particularly, of course, given that part of the problem between African states and the ICC, one might argue, is the lack of response. So African states making proposals and not really seeing response from various quarters. So proposals in relation to amendments, proposals in relation to deferrals at the Security Council, proposals to the prosecutor, now the independent expert review not really responding. So that's an argument that could be made, that at least there should have been this response to what African states had been talking about. It could be that the response to that would be, in fact, the point that Ambassador Cano already made, the fact that the time frame is really short in the period between the initiation of the expert review and the release of the interim report. Only one African state, according to the interim report, had actually met with the review process. But as he also indicated, there was this joint submission by African states later on. So that's the first response, that these are important issues. And so it's important to deal with them, even if you're not likely to get change in the immediate future. The second response would be that, in fact, actually, the independent expert review did consider some proposals that would require amendment. So even though they themselves say that for the most part, they were looking for reforms that would not require amendment, they didn't stick strictly to that. So to give one example, one of the proposals that they made was with regard to the ability of the judges to be able to make changes to the rules of procedure and evidence. And that requires an amendment to the statute, and they proposed that the statute should be amended. So there actually were occasions when they did consider and recommend an amendment to the statute. The third response, I think, that one can have to the position of the expert review, that they were only looking for actionable proposals which could be acted on immediately. The third response would be that actually maybe not everything that African states have been proposing requires a response, requires an amendment to the statute. Now, I think it's fair to say that the way that African states have put those proposals that I've mentioned, it's fair to say that these have been proposals to amend the statute. But I think, as I'm suggesting, if one stands back from the specific proposals, one can put them within this broader basket of the peace versus justice conundrum or debate, and then one can think more broadly as to how to address that issue without actually without actually requiring amendments to the statute. So, for example, the independent expert review does not talk at all, at least I can't find any reference, and I will put my hand up as Sharon suggested. I will put my hand up and say, I haven't actually read the entire 340 anything in the report that deals with the interests of justice question. So the ability of the prosecutor not to investigate, not to prosecute, where she or he decides that investigation or prosecution is not in the interest of justice. Charles convened in the summer of 2020, I think, well, SILPA, I think, convened, actually, I should say. Charles chaired, and Ambassador Cano was involved, and I think I know Sharon also was involved, a workshop where there was discussion of a paper that had been authored by Charles on this question of interests of justice and how it fits into the peace versus justice debate. Some of us have also written on this issue in the past. Of course, this was a question that came to the fore in the context of the Afghanistan investigation. And there are real questions, actually, as to how the prosecutor ought to be interpreting his or her power not to investigate in the interests of justice, and how that links to questions about ongoing peace negotiations, questions about the relationship between the ICC and other justice mechanisms. That's not to be found at all in the independent expert review. What's interesting, of course, is that the review does deal with the prosecutor's decisions relating to situation and case selection, deals with the prosecutor's ability to deal with prioritization, deals with preliminary examinations, and arguably the whole question of how to factor in interest of justice could have been dealt with in those sections. Maybe there's an opportunity to follow up on those issues. And maybe there's an opportunity for us all actually to continue to think about how those interests of justice questions should continue to arise, should continue to be thought of in the context of prosecutorial decision-making, in addition to all the prioritization selection issues that the independent expert review has highlighted. Thanks very much. Back to you, Charles.
Thank you so much, Dapo, and I'm glad that you were able to not only pick up on some of the important points made by Ambassador Cano and Sharon, but so also, if you will take a longer perspective in terms of timeline, going back to the beginning of the African concerns, and to address some of the issues that featured so prominently, I think most importantly, the peace justice debate, right? And we've been grappling with that issue for many years. And I think it has significant implications for the court, irrespective of the region of the world that the court is focused on. So the fact that you have a group of states parties that have had experience with that peace justice debate and have made concrete proposals should have at least provoked a discussion on the part of the IER about the issues, even if their view is that they were not tasked with making proposals for amendments to the Rome Statute. And I note, of course, Dapo, that you reflected a little bit on that workshop that we had, and I can share with you that we, in fact, I sent that to the chair of the IER process, suggesting that this is an issue that a group of scholars have come together to look at, and we think it should be taken into account, right? And obviously, we were a little bit outside of the timeline and what have you, but at least you can't say nobody alerted you. I think it probably is more explained, the lack of discussion of the issues more explained by the fact that they did not want to go into these sensitive issues. Obviously, issues of funding and other issues were also not taken up. The role of the ASP in terms of strengthening cooperation, there are some questions about that, and a whole host of other points. But let me pause and go to our last speaker, because I do not want to abuse the privilege of being a moderator. I know you've talked about peace, justice, and Yasin has, of course, worked on this issue. So Yasin, maybe you have now the opportunity to bring in your own scholarly work, but also as someone who watches closely what happens in the OTP from that African perspective. If you could take 10 minutes, and then we'll go to a very, I think, exciting conversation. So you have 10 minutes to give us your perspective. Thank you.
Thank you, Charles, and thank you to yourself and all the co-sponsors for this really important conversation. There's so much that's been said that have just invoked more of my thinking, but I want to invite us to have a moment of pause, and a moment of pause specifically about this idea of what is the African perspective. And I have always been interested in this because I think, you know, when one talks about regional blocks, there is a tendency to perhaps homogenize some very interesting nuances and micro trends that tell us about the way that continental politics can maneuver, especially when it engages with international institutions, international forums. Early after my PhD, I was lucky enough to sort of join the Gambian delegation that was attending the review conference in Kampala, and see very closely the way that African state parties were engaged in that discussion. And I always come away from that thinking very deeply and reflecting upon the necessity to ask myself, and I think all of us can consider this, who are the continental leaders? Right? The Sierra Leone, whether it's South Africa, whether it's Zambia, whether it's Cote d'Ivoire, because that also tells us like ways and opportunities to engage in sustaining engagement between African state parties, the African Union, African civil society. And I think that's where I would like to start from, because I don't think we should take it for granted that when we talk about African state parties or the AU, that all 54 countries or 33 African state parties will have equal voice in that working group in those discussions. And that's fine. That's the reality of geopolitics. But it's an opportunity for us to reflect upon the ways that then the court can engage with specific countries as a kind of entry point in dialogue with the wider regional bloc. So perhaps that's something we can pick up in discussion, and I'd love to hear from the ambassador specifically on this. The other thing with our understanding about the African perspective, to kind of finish off with, is the importance of African civil society. As Sharon has, you know, eloquently demonstrated in her intervention, I think there's so much that we need to reflect on when it comes to thinking about the ways that the Office of the Prosecutor, the ICC as an institution, engages with African civil society. And I think in tracking the work of the court throughout my kind of professional career, I've always been interested in the ways that the court can sometimes, the Office of the Prosecutor can often lean back to using the same civil society organizations. And I think in situation countries, in the African continent more broadly, anyone with any iota of familiarity of the way that one understands law, politics, and justice, lived experiences on the ground, the voice of one or two, or perhaps a handful of civil society organizations who are repeatedly invited to the table is frankly not enough. I think the Office of the Prosecutor, I think bigger civil society organizations, particularly located in the global north, should all be thinking actively to diversifying what we talk about, an inclusive dialogue, so that we do hear from as many voices and as many perspectives, because that informs the work of international criminal justice. And to say that with the seriousness and to take that task, with all the responsibility that it demands. So, with some of the logistical, practical, operational issues that Sharon pointed out, I think one of the other things to think about is exactly that, bringing the court much more proximate to those those individuals, those victims' communities that are its fundamental constituents. And perhaps this is where I depart from many in the audience, in that for me, while states are the primary engagers, ultimately, victim communities, without them, the court does not exist. It has no work. It doesn't come into being. So why should we use victim communities instrumentally and then push the entity of the state, the politics of leadership? I understand the reasons why, but I think, how do we recalibrate that balance? Because so far, what we can look back on retrospectively is that the ICC has had many difficult relationships with African states, interesting turmoil, but also I think in the last webinar, I think it was Dapo that mentioned like this moment of sort of calm before a potential storm brewing ahead. I think in this moment of calm, of quiet, of reflection, where and how could we further amplify and ensure that victim communities, which are also the situation countries, which are the sources of defendants, as well as witnesses, as well as victims, are included in the process? And I think not included in the sense of what the ICC wants, but really entering into what can often be difficult dialogues with communities who have many needs, who may not understand the intricacies of rules of procedure and evidence or all of that, but who nevertheless deserve our attention, care, and appropriate recognition. And certainly within my work, looking at the Gambian Truth and Reconciliation Commission, I've seen an institution try to bridge that gap. Now, of course, it doesn't have, the kind of sizable workload of the ICC, but it was interesting to observe how from the offset, the Truth Commission has been tried, it's now finished its work, to bridge that gap, to engage communities, to show that we are listening from the start. So for me, the independent review, while very interesting, and again, having not looked at all of 348, I was reading it and I was thinking, how would I translate this to somebody who has been a victim of an atrocity crime where the ICC has jurisdiction, which is the point Sharon raised earlier, which is an important one, right? The court should not just be speaking to those of us in the quote unquote international elite who have knowledge, research, expertise, and all of that. It should be speaking to its core constituents. And I think the independent experts did sort of pick up on this idea of working on the kind of outreach and engagement. But I think if we're really reflecting deeply on challenges and opportunities, that is something that occupies my mind a lot. And in listening to the various perspectives on this panel, I think that is sort of missing. So I want to foreground that, bring it back to the foreground, just to give all of us and the International Criminal Court, and particularly the Office of the Prosecutor, a reality check that is needed at all times. And I think there are imaginative and important ways to do that. There are ways that you can engage civil society organizations that are closest to victim communities. There are ways to engage the plethora of African legal expertise. Certainly I found with many civil society organizations in the Gambia that are new post the authoritarian regime of President Jammeh, that are new, that are learning, but the capacity building, the knowledge, the skills, the conversation, the co-creation and co-design, and the ingenuity on the African continent can be unparalleled. So why on earth should we sit back and say, or renegade these conversations to spaces within the global north? And I think this is where SILPA is doing an incredible role in bringing these conversations to bring African legal expertise, different perspectives around the table, and to nurture that. So I think when I read the review and the ICC's response, I was mindful of how one can continue to engage with victim communities at a substantive and sustainable level. So I think I'll pause there and then pick up in discussion if there's any particular intricate questions we can look at, because there were many, but I wanted to say that. Thanks, Charles.
Thank you so much, Yasin. I think that's it's a very important perspective, especially in the end. I think the point about the role of the victims is central to the process. I mean, the entire raison d'etre of the ICC, the whole idea of international criminal law, going back, we have the Nuremberg Academy here, going back to Nuremberg, is about the victims of these atrocity crimes. And when you read the preamble to the Rome Statute, it's precisely about the victims. So the question that you are asking, where are the victims in all of this? How do we address the concerns of those on the ground who are the ones who become the witnesses, who are the ones who end up supplying, right? And not in a negative way, but the defendants and the individuals who end up at the ICC, essentially to face up to the charges of what they have done. So I think it's really, really very, very important conversation. We've had a wide-ranging set of views. We started off with kind of like a state perspective, right? With Michael laying very nicely the background for what's happening at the state level, sharing with us what African states try to do in terms of a group submission to the process, raising some of the bigger questions that Dapo has flagged and talked about, the issue of interest of justice and so on. And then, of course, connects nicely to some of the concerns that Sharon raised about the African civil society participation. And you have brought us full circle in a way by emphasizing the importance of that aspect. So let me do this at this point. I'm going to invite the audience. For anyone who has questions, please feel free to put them in the chat or to raise your hand so you can actually make the intervention and ask the question if you want to do that. In the meantime, I have a whole host of questions for our panelists from what they have said, but I don't want to do that before I invite them, starting perhaps with Michael, if he wants to react to anything he's heard. And then I'll go on to Sharon and Dapo, and of course you, Yasin. And of course, it's always, Klaus, you are always welcome to intervene as well. Mark, I know, is there. Sharon, I know your camera is off, but you can hear us. So if you want to keep the camera off, that's okay as well. But Michael, perhaps you can now pause in light of all the presentations from the academic perspective, civil society perspective. Do you have any reflections?
Thank you, Charles. There's so much to reflect on from a state perspective. What I have done is basically just to highlight some important points, because a lot has been said by the eminent panelists. I'll just start with the civil society presentation by Sharon. And for me, I mean, one would agree with most of the things you said in terms of the challenges faced by civil society from situation countries and in Africa in terms of engagement in the review process. particularly this issue of the report itself being very complex and dense, very complex legal issues. We will be discussing unified governance, and it will take a lot. It requires some serious legal expertise in international law. So, but the issue I wanted to really, it was sort of a question. How do we approach in terms of issues from the African state perspective and priorities? Because when you were presenting, and I said, in my mind, was that these are civil society priorities. Are these aligned to African states? And this will get me to the question which you asked, yes, in terms of, so how do we come about developing the African perspective? Because it's important when you coordinate and you say, this is the African position. I briefly discussed this complex relationship between ICC and Africa, but it's the same for every issue. How do you develop position and present it as African group position? And when we do, it's usually from the state perspective, but how do we incorporate the views from, in the case of the ICC, the victim societies and non-state actors in terms of addressing challenges which we think African related in the African context. What I can explain or say from the state perspective, and just combining the two, is to say that, of course, it takes a lot of compromise and negotiation in the normal state-to-state process. But the underlying issue is this principle of solidarity. So there is no homogeneity in terms of African interests and priorities, but in the internal conversation, what underlines the African resolution and point is really solidarity. And so when issues are presented, it's presented as an African position. I'll take immunities, for example. The position, when you look at the substantive position of each state, is different. Sierra Leone's position on immunity of head of states and government and senior officials is different by reason of our own context and history. However, when you then move on to the African group position, it is this solidarity in which, how do you address issues? So do we want to address immunities? Yes, we want to. How do we address immunities? Do we accept the decision that was made by the ICC appeals chamber? Or do we want to use, for example, follow the African Union decision and propose advisory opinion, a question for advisory opinion by the ICJ? So these are the things we get to contemplate. We contemplate as state parties, and you make a strategic decision. But of course, there is no.
Oh, I think we were doing very well with the internet.
The challenge has been.
Okay,
I think I've been too long, right? So a quick one in terms of the presentation that was made by Dapo, again, as always, very, very helpful in terms of understanding these technical issues. Interest of justice really was part of the submission that we made. Thankfully, we had a good engagement with SILPA at the time. The question really is that the state party reserved unto ourselves certain issues which we're going to address, including complementarity, wherein you have most of this discussion in terms of the policies of the OTP, but also we now see the new approach by the new prosecutor. So there's still opportunity for these issues to be addressed. But really, what I wanted to voice out is that an agreement with you that eventually we saw in the report that even though the experts said they were not going to deal with amendments of the Rome Statute, eventually we saw in the report issues of amendment of the Rome Statute. So of course, it is eyebrows. The other point which I also want to put on the table is what can you point to as the real challenge in addressing the proposals that have been put forward by African state parties? Because in taking up proposals for amendment or in taking up proposals, there are ASP-specific processes. So what we need to investigate is how those processes have been engaged, utilized in the past. And I think that's a vital point which really has not been investigated and which requires some form of investigation. I will leave it at that, Charles, so that I'll save some time for my colleagues.
Thank you so much, Michael. I think these are very important interventions, and I'm glad that you raised some of the commonalities of the issues in terms of formulating a group position at the state level with the potential challenges that civil society might have in doing exactly the same, something that I think you invited Sharon to comment on. You also made a nice connection to Yasin's point about what exactly is an African position, right? I mean, I think this is Yasin's question. And when you say an African position, it's always interesting to reflect on the different individual national positions. And I've been part of AU meetings in Addis, I've been part of AU meetings in New York, and that complexity of who is leading the conversation in the group becomes very, very important. So if you talk about immunity, Sudan was critical to raising the issue of immunity. And this discussion and this principle of solidarity has implications for what became an eventual decision by the African states not to cooperate with the ICC because of the principle of solidarity, even though some of them had their different national views on al-Bashir and immunity and so on. So really, really interesting point. And then, of course, for DAPO, you've raised the issue of how do you use the processes? And it's interesting on the Article 16 question, we actually did a study that tried to map out the pros and the cons of the African position and some of the challenges for Africa ahead, especially after you make a proposal and then you leave the room and you don't come back into the room to participate in the process. But let me give the others an opportunity to intervene. Who at this point, maybe Sharon, you want to comment, and then we could go to perhaps to Yasin and then come to Dapo.
Yeah, thanks, Charles. I hope the sound is okay. Yeah, so I think in reacting to, Ambassador Cano asked, do we have alignment on issues of concern between states and CSOs? I can safely say, even without consulting with my, my fellow CSO colleagues, that we will disagree on immunities, without a doubt. We will disagree with you on issues generally around cooperation. That is without a doubt. But there are areas where we have alignment. We want the same thing for victims. We want a trust fund for victims that is, responds to the needs of victims. We want a proper victim participation process. We want victim assistance programs that are responsive to what victims want. We may at some point disagree on who we are prosecuting from the CSO perspective. But ultimately, I think we could focus and work together on those issues where we don't have necessarily any controversies or a difficult relationship. So I see an opportunity there. And going back to what Yasin said on engaging victims, like I said in my presentation, these are the key constituencies of the court, and we want a court that is responsive to the needs of victim communities. Now, going through the report, it was interesting. While the IER mentions, external or legal counsel for victims, the OPCV, you do not necessarily see points where they consulted them specifically on victims' views on the court. That was a missed opportunity. So if you look at the report, you'll see concerns around budget issues, funding victims' work. But did the IER, did the experts actually go out of their way to ask victims' counsel, the OPC, the external victims teams, about the perspectives of victims on the way the ICC operates? So I think there is an opportunity for the RM to consult such teams. If you want to know how best to package this bulky report for victims, you're better off speaking to the people who work with them, who have worked closely with them. You have the field officers who actually engage with civil society on the ground, not we, the elite civil society who are able to attend these Zoom meetings as and when, but they are the ones who engage closely with them. They can tell you how to break down this very complex process for these communities. I've worked in the field. We would literally explain a very complicated legal process to victims who do not speak the language of the court, who will probably never come to The Hague. But these are the people who have built, when you are working with victims, you build that level of trust. They're able to listen to you. So I think there is a benefit in using some of these existing teams, or in the field office itself, or even teams of lawyers that work with victims. Thank you very much.
Thank you so much, Sharon. And I'll just note before you intervene, Yasin, that there are some questions that were, I think, one of which was, at least two actually, of which were directed to you. So maybe you can have a look at those and see if you can answer. I think one is from Eugene Bakama, and then another is from Martha Schmidt. Both of them addressed directly to you, and perhaps even the third one. Of course, I invite the other panelists if they want to weigh in on these issues in response. Perhaps so we can go through some of those questions. We'll keep the answers brief, and we'll do another round as well. So Yasin, why don't you start us off, and then I'll come to Dapo next.
Just looking at the question. So Marta's question, I think Sharon is better positioned to answer that. So I will hand the baton over to Sharon. I do have views on that, but I think we have the expertise here, and I'm happy to defer to that. And the other question you said was from Eugene. I think it would be more difficult for the international criminal justice to be closer to the affected communities for many reasons. Eugene, thank you for that question. I would agree and disagree in the sense that I would agree with you in a kind of broader sense of feeling that international criminal justice can often be relegated to this idea of justice in The Hague. So, which realistically, for lots of reasons, one can understand that perspective. But I think this is where I perhaps pivot slightly. And I would say that international criminal justice is not limited and monopolized to The Hague as a concept, as a project. It can be pluralistic in its vision and imagination. And certainly when you have complementarity inbuilt within the Rome Statute framework and as a kind of anchor to how the court should work, I think that is a real opportunity to think about justice at the national level where possible, right? And I see this in many different contexts that I've both worked in, but again, I'll pull Gambia because it's my kind of most recent field experience. In Gambia, and sorry, I should say I am from the Gambia, I am Gambian, so the possibilities of having prosecutions domestically from speaking to victims' communities across the region is I think has that tangible connection for people to see justice be done. There's all talk about a special court similar to the extraordinary chambers that tried Hissène Habré. But when you sit and spend time with communities, so not only just ask victims, but you spend time with communities, and Sharon, I'm sure, has this experience as well. When you've spent time to understand communities and their needs, then you start to see the necessity for justice to be proximate, much closer, and the importance of that, both to those who are victims and survivors presently, but intergenerationally. It can transform a national domestic landscape if you invest in justice at a national level. That's not to say that the international is not important, but I perhaps have hold close this idea that justice should at least be as proximate as possible. And Sharon has given us ideas for that, field offices, the ways in which international justice at The Hague can be brought a bit closer, and the report did as well. But I'll hand back to Sharon for the question about funding.
Thank you so much. Yes, and Sharon, do you want to react on that aspect? Is an important aspect.
Oh yeah, Martha, that's a very interesting question. And I wonder if the response I'll give you will be satisfactory. So the thing that we have seen, say, in our limited philanthropy experience is that you may fund, but do not dictate how the NGOs go about their work. I think that is really important. So the fact that, yes, we will fund the work of African NGOs in order to facilitate their engagement with these processes. So as I mentioned in my initial remarks, for example, we supported the African Network on International Criminal Justice. We have supported SILPA without necessarily dictating to them how they should go about the work. So I wouldn't say that it limits engagement with the court, no. Rather, we also try, one of the things that we have seen in the past that has helped us is also facilitating access of NGOs to the ICC itself. We have a team based in The Hague that helps us coordinate this, because OSF is a long-term partner of the ICC. So we have a team that actually helps these NGOs as they navigate this very complex, Hague, very highly political environment, engaging with the organs, just making sure that they have access to these court officials. So I wouldn't necessarily say that it limits. Rather, the approach we have taken is to actually facilitate or improve the engagement of NGOs, African NGOs, with the ICC. It is not without challenges. That's just the reality of how things work. It's not without challenges, but I think if you look at it more from playing a facilitating role, then you are likely to reap the benefits. Martha, I don't know if I've done your question justice, but that's where I would leave it.
Thank you so much, Sharon. I think it's an important intervention from Martha, and of course, an important response from you. I see a connection between the point that you are making about the shift of the NGO attention towards the pandemics. My own experience, limited as it is with African civil society, is that you follow the funding. So the priorities may change with what is available. So it's an important issue in terms of thinking about African philanthropy and who is funding these initiatives on the ground, because in as much as we talk about international justice, I think the anchor, and I think Sharon, you made it very clear that you and Ambassador Cano in this capacity as a state representative might disagree, but you all are on the same boat, heading towards the same destination, right? You would not agree on all the detail, but that common endeavor to get that accountability for the victims shared by the states as well as African civil society is an important point of connection. So Dapo, let me invite you at this point to intervene and react to anything that you've heard so far, things that were directed to you, and perhaps to, as I look at the time, I think we have about 10 more minutes or so. If you want to have any final reflections as well, you could weave them in at this stage, if you don't mind.
Thank you. Thank you very much, Charles. Maybe I can just take some of the questions that are already showing up in the chat and in the Q&A and respond to them. Before I do that, let me just say that when I was talking about the concerns of African states earlier on, I don't necessarily share all of the, I don't agree with all the proposals that African states have made. I don't agree with all the proposals around the amendments. The only question is, what kind of reaction should that have got? And to what extent should that have been reflected in the independent expert review? Now, Eugene asks, in relation to the question, this is in the chat, in relation to the question about amendment to the statute. And I said, the independent expert review, perhaps one might have taken the view that they didn't respond to these concerns because they didn't want to take on issues that would require amendment to the statute. And he asked why the question of amending the Rome Statute looks like a taboo. As I said, they actually did take on some of those questions relating to amending the statute on other issues. I mean, there's an understandable concern about suggesting amendments to the statute just because it's so difficult. This is something that's provided for in Article 121 of the Rome Statute. And other than the provisions relating to the definitions of the crimes, you need 7/8 of the states actually the states parties to ratify these amendments for them to come into effect. So the bar is incredibly high, and you can see why people might say, this is just so high that it's not really practical, and we're going to look for things that are a bit more practical. So that's just on your point, Eugene. And Adil in the Q&A asked a question around prosecutor and Saif Gaddafi and the peace and justice issues. and how interests of justice should be dealt with there. So, I mean, this gives me an opportunity to say a little bit about my own views on questions relating to interests of justice. So, I mean, the basic thing that I would say is that the prosecutor, or rather the office of the prosecutor, because it's not this current prosecutor, the office of the prosecutor has a policy paper on interests of justice where they have taken a very, very narrow view of what that provision, Article 53, provides for. And my own view is that it's actually unduly narrow, and I don't actually think that the view that they have taken of interests of justice is consonant with a proper interpretation of the statute. Basically, what the Office of the Prosecutor's policy paper has said is that anything to do with peace is to be, it's relegated to other bodies to deal with. So not our business, because Article 16 says deferrals, that's the Security Council. So really not for us to touch those questions. And I don't think that that is, I don't think that that's both on legal and policy grounds, the best interpretation of Article 53. On legal grounds, I don't think it's the best interpretation of Article 53 because when you look at the way in which it is framed, it actually contrasts, at least in one of its provisions, the interests of justice against other interests, right? So it actually suggests that the interest of justice is something that brings in other considerations which go beyond some of the factors that are mentioned there. And so it doesn't actually exclude taking into account broader justice considerations. For example, the extent to which you have mechanisms which deal with restorative justice. For example, the extent to which the goals that retributive justice is trying to achieve, the extent to which they can be achieved and might be better achieved actually by other mechanisms. So I actually think that there is scope to include broader factors in that. Now, I don't know specifically how I would think about the Saif Gaddafi situation. For me, interest of justice is not just about interest of peace, though. I think that that is important, that interest of justice is not just a proxy for peace. It really should be looking at justice, but I think justice more broadly. So, for example, if you have peace negotiations that are ongoing, which take into account, for example, restorative justice mechanisms, where there is broad support, which is expressed in a sort of participatory process by the victims. And Yassine was talking about the interests of the victims, and I think that's, that's preeminent. If there's broad support for that, then you can take those things into account. And I think as the prosecutors, in any event, going to take these things into account when they're thinking about selection of situation, prioritization, it seems a bit strange to say the prosecutor can't take it into account when the prosecutor is thinking about the interests of justice. So that's my view on that issue.
Thank you so much, Dapo. And I'm glad that you had your eye at the chat as well. So you brought in additional questions, including some that went up after I last looked at it. I really like the point about the interest of justice as an area where there could be some possibilities under the new leadership of the OTP, because there is, I think, in the discussion that we had in that workshop that you alluded to earlier, where there's a sense that maybe this is an opportunity for the OTP to revisit the narrow interpretation. And I agree with you completely on that narrow interpretation of what the interests of justice mean. And by the way, at the African level, one thing that I could flag here is we have now the AU Transitional Justice Policy Framework that talks about sequencing peace and justice, right? So there are actually concrete ideas that one could look to, at least if you think of it from the perspective of African states, of how you can input into that process and how that could look when you talk about the Rome Statute and its longevity. I do want to make a couple of observations about some things, and I don't know whether Klaus wants to intervene or others want to intervene at this point. But it's interesting to me when you think about bringing the court closer to the people. We have had experiences that are generally very successful. If you think about the experience of the Special Court for Sierra Leone with outreach in Sierra Leone. But outreach is very, very expensive. And I know that in the report of the experts, they talked about strengthening this area. So on the one hand, we want the court to be closer to the people on the ground. But if you think of it in terms of capacity, the court has no money. They are told it's a zero growth policy. So this is really an issue for the states to consider when you have this ambitious discussion about ICC reform, bringing the court closer to the people. Well, what if you give the court more than it can chew when you don't put the resources to deal with all these different situations that are expanding, including, by the way, the Security Council referral? So that's just one observation. I just one other thought before I invite others to comment at this stage, and I'll look at the chat if there are additional questions and invite you to close up, is to note this business of putting proposals and perhaps abandoning them. Now, I would say, like Dapo, since I'm an academic, completely not necessarily always agreeing with governments in terms of what the positions are. Obviously, that goes without saying in a way, right? But the effort should be to be organized around your key priority issues. And I know from the perspective of Africans, this is very, very difficult. But too often, whether it's in the working group on amendments or in other fora, there will be a proposal put forth and there's no follow-up. You could say that about the South African proposal when it comes to Article 16, the issue of deferral that Dapo talked about earlier. You could say that about the Kenyan proposals concerning, Dapo talked about the immunity aspect, but they also had a very, very interesting proposal concerning complementarity. Now they may have lost political interest in the immunity question, but I think the complementarity issue remains very important because of the point about the Malibu Protocol and the idea of, African-based justice. So just to say that there is on the part of African states as well, a responsibility to engage, and this is where civil society and African academia could perhaps assist, given that I know that there are capacity issues as well. So I'll stop there, and I would invite, I think, others. I don't know, Klaus, if you wanted to comment on anything, or go ahead, please.
Well, thanks very much, and fascinating discussion. Could go on for a couple of another hours. I would not get tired to listen to it. Well, what you just mentioned is an interesting aspect. Is there an alternative to the ICC? Would the Malibu Protocol, which remains a theory, be a true alternative? Well, one thing should not happen. If African states under the Malibu Protocol would run away from this court, like Burundi ran away from the ICC, the moment it gets serious, the moment it affects themselves, then the whole idea is going to be very, very fragile. And the same applies actually to Kenya, with all respect, but talking about immunity restrictions is a direct attack against Nuremberg Principle number 3. So one has to be extremely careful with these things. And one last remark maybe to the monetary aspect. You mentioned zero growth policy and the risks inherent to that. I think it goes beyond. We see at the moment the tragedy of a court that is driven into bankruptcy. And I'm talking about the Special Tribunal for Lebanon, which is simply dried out by cutting off the funds. That should not happen at the ICC, but the risk is there simply by state parties not paying their assessed contributions. And we see that as an increasing risk and a threat to the ICC. We see this as a threat to the United Nations. We see that as a threat to a variety of multilateral organizations. And that is something that is worrying. And I think it requires actually the joint voices and the joint forces of everyone that this is not going to be tolerated. We are not going to actually stop justice by simply drying out the sources and withholding the funds. That is indeed a very high risk, and I really would like all states, not only the African state group, but all states unite here in working against that.
Thank you so much, Klaus. I'm going to just say one quick thing and invite the last three panelists to take 1 minute each so we can close. I think Dapo already gave his final reflections. And which is to note that the changes in the leadership of the OTP may suggest that there will be some changes as well down the line, as one could expect. So one of the things that ties into funding is, for the first time, the prosecutor appearing before the Security Council called out the Security Council in a way that hadn't happened before. Now, Madam Bensouda did call the Security Council out, and calling them out in the sense of paying as the statute requires. So Karim, I think, has raised that bar a little bit higher. Whether that will result in changes, we know what is behind it. It's just to note that there's some encouraging developments in that regard. So the idea is, if you make referrals, you've got to pay for the referrals. So you don't just give the work to the court without the check to make that work possible. Otherwise, you are going to undermine the purpose of the court. So let me bring it to a close at this point. I invite our last three panelists. So Yasin, maybe 1 minute, and then Sharon, and then Michael, and we'll have to bring it to a close. I think this is the beginning of a conversation. We started a little bit late, so hopefully folks will bear with us as we take the last few minutes to wrap up.
Yeah, I think my last comment is just going to be about the Office of the Prosecutor. I think there is something really important to remind us or help us to keep cognizant about, is that while the prosecutor is the public figure, and after the election process that we just saw, you know, there were many things in the independent experts report that point to significant institutional failings within the office itself. One thing that caused deep alarm for me is that where the independent experts pointed to the 50-50 gender parity in the Office of the Prosecutor, but also the fact that you do not have women in senior leadership positions within the Office of the Prosecutor, obviously at the time, bar the prosecutor herself. Now, I raise this because I think with all the expectations and burdens and pressure points that the Office of the Prosecutor will obviously receive, there is a need to be aware that there is going to have to be some transformative institutional cultural changes that are also happening alongside all of the other demands that we're talking about, right? And so that's not to excuse or give them a pass, but certainly having worked with many other large organizations, when they are faced with a report as candid, as thorough, and as challenging as the report, independent experts report did, I thought to myself, one has to get their own house in order, while also doing the business of international criminal justice. I'll leave it.
Okay, thank you so much, Yasin. I think it's an important call, and it's nice to see that the principals are already attaching themselves to the idea of improving the workplace culture at the court, issues of harassment and so on. So it's a really, really important point. Sharon?
Yeah, thanks, Charles and colleagues. I guess for me, one of the most important things is that we must move away from this entire PR approach we've taken to CSO engagement. So if you look through the IER report, if you look through the ICC's response, it's quite colorful with so many references to CSO engagement. But when it comes down to reality, I hope, Charles, when we have a conversation 6 months from today, we would actually have seen actual engagement with civil society, not just civil society in The Hague, but civil society in situation countries. And I'm glad that Ambassador Cano is here, and he's, you know, co-lead of the RM. And I hope at some point you will be able to actually visit these situation countries and speak to CSOs and speak to victim communities. And of course, that at some point, the ICC will be the one leading and implementing some of these recommendations, that we'll see this happening. What we've seen in the past is that this is a very state-centered, state-centric process. You know, every other minute you'll see what states think about it. They have recommendations, but at the end of the day, it's the court that's going to implement it. So we want to see the court at the center of implementing these recommendations. Their response is a good start, keeps us optimistic. But again, Charles, next conversation 6 months from today, we'll be able to find out if that actually happened. Thank you.
Thank you so much, Sharon. And I think the last word now gets to come from my Ambassador Cano, who has to share with us basically a little bit. I think you did a bit in the chat about the plan in terms of the victim-centered recommendations, but also a big picture in terms of the whole process that you're involved with in terms of the review mechanism and the comprehensive action plan. Michael.
Indeed, Charles, I think there are two parts to my final remark. Firstly, in terms of the African perspective and African engagement, this is an ongoing process. It's quite complex, as we know, but the idea is to see that there's continuing engagement in the assessment of the recommendations, because it is the state parties themselves that will have to follow areas of interest. And as was indicated, whether it's work in The Hague or in New York, in the study group, or complementarity or cooperation, really you get action in your proposals when you're fully engaged in the process. And so the promise is really to follow with that in terms of the African state parties' perspective. On the review process now, we're in the heart of co-chair. What we intend to do in this early part of 2022 is to put out our program of work, which explains clearly the recommendations which the review mechanism itself will assess in 2022. And once we've done that, we'll follow the comprehensive action plan. The idea is to have to decide on the most suitable way to assess recommendations. So for example, on unified governance, we've opted for a consultative approach. It's a difficult, dense legal issue, and so we want to consult. On a victims issue, it might be a roundtable where you have everyone interested on victim issues to be seated, and we have this discussion. And really, the review mechanism does not hold substantive position. Rather, we look to follow and rely on the comments of state parties, civil society. I mentioned in the chat that we've met with the OPCV, the Office of and the Trust Fund for Victims as well, regularly when we were assessing the more structural institutional recommendation. And so when we get to those other specific issues which are contained in the IAR report and the recommendations, the idea is that we'll get full engagement. And as Sharon has noted, I think that's where civil society will also come in strongly, because this was part of the priorities which they highlighted in the ASP 20. So as a review mechanism, we'll continue to call on your support and cooperation. We are leading the process, but of course the process belongs to everyone. And we've really had very clearly the message on transparency and inclusivity, including ensuring that we have we try as much as possible to have translation. Visitation to situation countries is a resource issue, but there is a honest and really we're striving to ensure that we're able to reach as many people as possible and interested stakeholders, so we have a process which could be legitimate. Legitimacy is really the key word in the work of the review mechanism and the review process. And so that is why we'll have to thank Center for International Law and Policy for doing this, and of course the American Society of International Law and the Nuremberg Academy for providing this platform for the review mechanism to engage and provide some explanation. Thank you.
Thank you so much, Ambassador Cano, and thank you to all of you, the speakers who have given. I think that we've started a conversation and we're going to continue this conversation by necessity of the nature of the process itself. In terms of a closing remark, let me just say that we'll be convening again to have more discussions, but to also flag that ultimately what we're discussing here is not just about African states as such and their participation. It's also very striking to me when you look at the report of the independent expert review process to see that only 22 out of 123 states parties either met with the IER process or made a written submission. And when you look at the 22 and you drill down, 15 of them were from the WEAR group, 3 countries from the Americas, and of course, only a handful, 1 each from Africa, Asia, and Eastern Europe. And when you add up all those continents that were not represented, they constitute 98 of the 123 states parties. So it's significant for the efficiency and effectiveness of the review process to have the input and the buy-in, because ultimately, as we all know with the Rome Statute System, these states are the ones that will be getting the cooperation requests, that will be dealing with the prosecutor, that will be dealing with issues of the victims. So if for nothing else but for the success of the project as a whole, we cannot lose the review opportunity to strengthen the institution in a significant way so that it would meet the promise that it has set out ambitiously, or states have set out for it ambitiously in the Rome Statute. So thank you so very much for making us part of your day. We've gone a little bit long and I apologize. We definitely will continue to call on you for your expertise and look forward to your continued engagement in the future. Have a good rest of your day or your evening, wherever you may be. Bye for now.